We congratulate both the teams and extend a cordial welcome to all the judges and members who have joined us here and in the live stream. We would like to mark the beginning of the final rounds with a brief of the case study prepared by the organizing committee.
We welcome you on board to decide on the matter of the arbitration between Megabank plc, the claimants from London, and ESGmbH, the respondents, a corporation registered under German laws. On 1st December 2018, FDS in Brazil agreed to sell 10 containers of frozen Brazilian beef to GF in Germany. The containers were to be shipped from Curitiba in Brazil to Stuttgart in Germany. The transshipment was to be insured by GVAG with a price rate of $500,000 by irrevocable letter of credit issued by the claimants who were financing this transaction. On 15 December 2018, FDS arranged the carriage of the said beef with DMM in Curitiba, who acted as Brazilian agents for the respondents for collecting the goods by truck from a cold storage outside Curitiba and their delivery to GF's premises outside Stuttgart. On 13 January 2019, DMM issued a multi-dock 95 MMT bill of lading together with an addendum to FDS acknowledging the receipt of the 10 containers from FDS's premises and agreeing to carry them to GF's premises in Stuttgart Industrial Estate. This bill provided for English law and Singapore arbitration. On 15th January 2019, from Curitiba, the 10 containers arrived by truck in Porto Alegre in Brazil and were immediately shipped on CRGN's coastal reefer vessel Senhora Pilar for Santos in Brazil. On 19 January 2019, at Santos, they were transshipped and loaded onto LS's reefer Odyssey C for Europort in Rotterdam. Meanwhile, the MMT bill dispatched by ES was received by MPLC on 19 January, who honored the letter of credit. On 2nd February 2019, from Europort, the containers were loaded onto 10 trucks engaged by the respondents and left in 2 convoys of 5 each. 5 trucks delivered containers 1 to 5 early to GF. The claimants, fearing for GF's solvency, asked the respondents to deliver the containers to a cold store in Hamburg selected by them and handed over the MMT bill to ES. ES replied saying that the containers 1 to 5 had already been delivered to GF, but they successfully contacted the drivers of the trucks loaded with containers 6 to 10, who delivered them to Hamburg instead of Stuttgart. By 5th February 2019, it was apparent that GF were entirely insolvent. MPLC immediately took steps to resell containers 6 to 10. However, upon inspection, it became clear that the meat in them was fit only for pet food, for which it was sold the very next day for $74,923 with sale expenses. The only evidence as to the cause of the spoilage, as per the inspection report by a Hamburg firm of investigators, was that the cold store in Santos, where the meat had been stored during transshipment, had been set to a temperature of -7 degrees Celsius instead of -18 degrees Celsius. And this must have been obvious to CRGN when they delivered the meat for storage there. The points of claim by MPLC for containers 1 to 5 are: claimants were party to the bill and the goods were not delivered to a consignee. Respondents breached the contract by delivering the containers to GF. Alternatively, the respondents converted the containers as claimants had the immediate right to possession. In either case, the claimants are entitled to recover the containers' value. For containers 6 to 10, they were not kept at -18 degrees Celsius. Alternatively, the defendants breached Article 3, Rule 2 of the Hague Rules. Article 3, Rule 8 of these rules renders Clause A1 of the bill null and void, and claimants seek damages of $584,115 with compound interest. The claimants nominate Professor Simon Bowen as the sole arbitrator. Points of defense raised by ES for containers 1 to 5 are: the claimants were not party to the contract under the bill. The claimants had no proprietary rights in the goods or immediate right to possession. In any case, the claimants can recover only their loss and not the value of the containers. For containers 6 to 10, ES is not responsible for the spoilage under Clause A1 of the bill. The incorporation of the Hague Rules is voluntary, and Article 3.8 will not strike out Clause A1. Any alleged breach of Article 3, Rule 2 is irrelevant. Respondents claim for a panel of 3 arbitrators under Rule 6.1 of the SCMA rules. Respondents accept Professor Bowen's nomination and reserve their option to nominate a second arbitrator.
We welcome you all to the final round of 8th National Law University Odisha, Bose Mitra and Company International Maritime Arbitration Mode 2021. We thank all the members for joining us here and online. Before we proceed, I would like to introduce the panel of arbitrators for the final round. We have Mr. Amitava Majumdar, Managing Partner of India's leading maritime firm, Bose Mitra and Company. Next, we have Professor Simon Bowen, who is the Professor of Maritime Law at Swansea University. Professor Andrew Tattenbaum, who is the Chair in Law of Shipping and Trade at ISTL, Swansea University. Next, Dr. George Lerodas, who is Assistant Professor at the ISTL, Swansea University. Last, we have Mr. Puneet Oza, who is Executive Director and Registrar of Singapore Chambers of Maritime Arbitration. I once again extend my cordial welcome and gratitude to all the arbitrators to join us. We are here today in the matter of an arbitration between Mega Bank PLC and ES GmbH. We have Government Law College Mumbai representing the claimants, that is Mega Bank PLC, and ILS Law College Pune representing the respondents, ES GmbH. The court is in session now.
May it please the Honorable Tribunal, I am Speaker 1 representing the claimants today. Before I begin, I'd like to clarify that I'm audible and visible to everybody.
Yes.
Okay. Before I begin, I'd also like to tell the Tribunal that I am slightly unwell, because of which I may have to stop to catch my breath every now and then. I request the Tribunal to please bear with me, and I apologize for any inconvenience caused. With that out of the way, I'll begin straight up with my contention, since the Tribunal is already well-versed with the facts. The claimant's first contention is that the arbitration is to be presided over by a sole arbitrator. Our first submission in this regard is that the SCMA rules provide for the application of the International Arbitration Act. Rule 22.1 of the SCMA rules state that unless otherwise agreed by the parties, the juridical seat of the arbitration shall be Singapore. Where the seat of arbitration is Singapore, the law of the arbitration under the rules shall be Singapore law and the International Arbitration Act. There is now even greater clarity that if the juridical seat is Singapore, as mentioned in the case study, and the SCMA rules apply, the law of arbitration under the rules shall be Singapore law and the International Arbitration Act of Singapore. Hence, with regards to the arbitral procedure, reliance based on provisions of the International Arbitration Act will apply, and hence the claimant's appointment of a sole arbitrator was well-founded. Further, I'd like to bring to the tribunal's attention Section 15A of the International Arbitration Act, which reads as follows. It is thereby hereby declared for the avoidance of doubt that a provision of rules of arbitration agreed to or adopted by the parties, whether before or after the commencement of the arbitration, shall apply and be given a full effect to the extent that such provision is not inconsistent with the provision of the model law or this part from which the parties cannot derogate. Now, I'd like to bring to the tribunal's attention that Section 9 of the International Arbitration Act, which provides for appointment of arbitrators, falls under Part 2 of the Act from which the parties cannot derogate. And hence, it is the claimant's submission that a sole arbitrator must be appointed based on the International Arbitration Act of Singapore. I will now move on to my second contention with regards to the claims for containers 1 to 5. The claimant's contention in this regard is that the respondents were in breach of the contract contained in the MMT bill to which the claimants were a party under the Carriage of Goods by Sea Act 1992 and common law. Our first submission in this regard is that the claimants have title to sue under the Carriage of Goods by Sea Act 1992. The first submission that the claimant would like to make is that the claimants fulfill the requirements laid down in the Act to qualify as holders of the MMT bill. Section 2, subsection 1A of the Act provides that a lawful holder of a bill of lading shall, by virtue of becoming the holder of the bill, have transferred to him and vested in him all rights of suit under the contract of carriage as if he had been party to the contract of carriage. Under Section 5, subsection 2, our researcher has pasted the relevant provisions for the tribunal's perusal. Section 5, subsection 2 of the Carriage of Goods by Sea Act 1992 lays down two elements that must be satisfied for a person to be a holder under the Act. First, he must be in possession of the bill of lading. Second, he must either be a consignee, an endorsee to whom the bill of lading has been delivered, or a person to whom a bearer bill of lading has been delivered. Under subsection 5, subsection 2, a lawful holder is a person who falls under the definition of holder and has become a holder in good faith. The MMT bill, which was consigned to the order of the seller FDS, was duly endorsed in the name of the claimant. Now, this is evident from the face of the bill of lading. If I may direct the tribunal's attention to page number 12 of the case study. Page number 11 of 24 of the case study. It is clear that the bill of lading has been endorsed by FDS to the order of MPLC in this case, and therefore the bill of lading was duly endorsed in the name of the claimant. Therefore, it is submitted that claimant on the receipt of the bill of lading became the possessor of the bill of lading on 19th January, hence satisfying both elements to make a person a holder under the bill of lading.
Can I intervene at this point? Can I ask a question at this point? You've addressed us extremely informatively, but can you answer the question, is this a bill of lading within the Carriage of Goods by Sea Act 1992, since it does not only involve carriage by sea? Maybe we're coming to that. If so, I apologize.
Mr. Arbitrator, it is the contention of, it is a submission of the claimants that under the Act, a bill of lading, a contract of carriage under Section 5, subsection 1 of the Act is defined only as a contract of carriage in relation to a bill of lading or seaway bill, which means the contract contained in or evidenced by that bill or way bill. It is clear from this definition that it does not restrict itself to only carriage of goods by sea, and hence it is the claimant's submission that this MMT bill will fall under the ambit of the Carriage of Goods by Sea Act. Additionally, the Carriage of Goods by Sea Act also gives recognition to the bill of to receive for shipment bill of ladings, which in this case the MMT bill is. If that answers the tribunal's question, I'd like to continue with my submissions.
Can I come back to being rather stupid? What if this bill of lading had provided entirely for land transport? would your answer be the same?
Mr. Arbitrator, it is the claimant's submission that under common law, a bill of lading is one that does evidence a contract of carriage by sea, and therefore a land bill of lading may not fall under the ambit of this act. But because in this MMT bill there is a significant leg of the shipment carries a contract of carriage by sea, this bill of lading will definitely fall under the Carriage of Goods by Sea Act 1992.
That makes life much clearer. Thank you so much.
And would it be as a further follow-up to Professor Tessenbaum's question, would it still be a bill of lading if you had an insignificant amount of sea carriage involved in the total carriage under the so-called bill of lading?
Mr. Arbitrator, the law in that matter is quite unclear, because of which the claimants would refrain from commenting on that particular instance. But it is agreed by various authors that as long as there is a significant leg of the transport covered by sea carriage, an MMT bill will fall under the ambit of the Carriage of Goods by Sea Act. If that answers the tribunal's question.
Thank you very much.
Thank you. It is further submitted that under the Carriage of Goods by Sea Act, the endorsement and delivery of the bill of lading to the financing bank will result in the transfer of rights under the bill of lading contract to it. In Standard Chartered Bank versus Dorchester LNG Limited, it was held that the bills of lading were endorsed and transferred to the claimant bank, making it the person with possession of the bills of lading upon it honoring the letter of credit. Therefore, in that case, the financing bank became the holder of the bill of lading on receipt of the bill of lading and honor of the letter of credit. Similarly, in the current scenario, FDS endorsed the MMT bill in favor of the claimants and delivered them to the claimants, making the claimants lawful holders of the MMT bill on 19th January upon honoring the letter of credit. Just to make matters even clearer, I'd like to also cite the case of East West Corporation versus DKBS, where it was held that where the bill bears a personal endorsement and is held by the endorsee, his right as a holder of the bill of lading is personal to him. In such a case, there is no difficulty in identifying him as the holder under the Act. I'd like to draw the attention to of the Honourable Tribunal once again to page 11 of the case study, where it is clear that the bill of lading bears a personal endorsement in the name of the claimant, therefore making it clear that the claimant is the rightful holder of the bill of lading. If the tribunal is satisfied with my first submission, I'd like to move on with my second submission, which is with regards to the claimant's title to sue in common law. My first submission in this regard is that in Sanders versus McLean, it was famously said that during the period of transit, the bill of lading is universally recognized as a symbol of goods it represents. And the endorsement and delivery of a bill of lading should pass just as under similar circumstances, property would pass by an actual delivery of the goods. This is a well-established principle of common law. And Paul Todd, taking the statement to its logical conclusion, stated that a bank under documentary credit, which holds the bill of lading, has title to sue in common law, where the carrier has delivered without production of the bill of lading, even if the delivery was made to the buyer. It is thus submitted that as holders of the MMT bill, the claimants have title to sue the respondents in conversion for misdelivery.
Do you not? Can I just ask another awkward question? What about the argument that the bank took this bill of lading merely as agent for the buyer, there being no evidence that it was holding it as security?
Mr. Arbitrator, I'd first like to bring the attention once again of the tribunal to the case of East West Corporation versus DKBS, where it was contended that the bank was holding the bills of lading as a mere agent. However, it was held that because the endorsement was personal to the bank, it was clear that the bank was the holder of the bill of lading with title to sue.
Thank you.
My next submission is that the respondents acted in breach of the contract contained in the MMT bill. The MMT bill in clause 8, subclause 2 of the MMT bill in clause 8, subclause 2, which can be found on page number 9 of the case study, page number 10. If I may direct the attention of the tribunal to clause 8, subclause 2, it states that when the empty bill of lading has been issued in a negotiable form to order, to the person, the delivery must be made to the person surrendering one original of the document duly endorsed. The respondents clearly breached this term of the contract by delivering the goods without the surrender of the bill of lading to GF. Further, in Sehai Tong Bank Limited versus Rambler Cycle Company Limited, it was the opinion of the Privy Council that the delivery by the carrier without the production of the bill of lading was a fundamental breach of the contract. It was held that it would run counter to the intent of the contract, which was the proper delivery of the goods by the shipping company unto order or his or their assigns. The object of the contract would be defeated entirely if the shipping company was at liberty to deliver the goods to somebody who's not entitled. Further, a ship owner who delivers goods without the representation of the presentation of the bill of lading does so at his own peril. It is thus submitted that the MMT bill was made out to the order of FDS and was duly endorsed and delivered to the claimants. By delivering the goods without the production of the bill of lading, the respondents failed to deliver the goods unto the order of FDS or their assigns. At this point, I'd like to ask the tribunal if there are any queries that they'd like me to address.
One thing, sorry, I'm speaking too much as I do. It's a bad habit. Do your clients also rely on liability in conversion as well as liability for breach of contract?
Yes, Mr. Arbitrator, we rely both on breach of contract as well as liability in conversion.
Thank you.
I think that position will be clearer once I establish the fact that the claimants did have an immediate right to possession of the bill of the goods as lawful holders of the bill of lading. First of all, it is reiterated that the claimants, by the claimants, that during the period of transit, the bill of lading is universally recognized as the symbol of the goods it represents. Thus, as holders of the MMT bill, the claimants were entitled to possession of the goods. Further, it is submitted that the claimants had a right to possession of the goods by virtue of being issuers of letter of credits for the goods. The bank's interest in a bill of lading is in its attribute as a negotiable document to title, capable of providing the required security for the credit. In the event of the creditor defaulting, the bank can thus assume control of the goods through the bill of lading and so recoup its loss. The security of a bank under a letter of credit lies in its rights as the holder of the bill of lading and thereby to possession of the goods. The endorsement of the bill in favor of the financing bank will confer a security by way of a pledge, enabling it to obtain delivery of the goods for the purposes of security. I'd like to point the tribunal's attention to section 19, subsection 2 of the Sale of Goods Act, which says that when a bill of lading is endorsed to the order of the seller, it is the prima facie intention of the seller would be to reserve disposal of the goods. Here in this case, it is clear that because the bills of lading were delivered to the bank and the bank honored the letter of credit based on the delivery of the bill of lading, there was a clear intention of the seller to reserve disposal of the goods or reserve its property in the goods until payment was made by the bank to the seller upon production or upon delivery of the bill of lading. It is thus clear that the bank held property special property in the goods as pledges in the goods, and therefore, because the goods were delivered without the production of the bill of lading, the bank will have title to sue in conversion. I'd like to ask at this point if that answers the Honorable Arbitrator's question.
It answers it very amply, and thank you very much indeed.
Thank you. With that, because that answers Mr. Arbitrator's question, it seems that I have come to the end of my submissions. I'd just like to conclude by submitting that the endorsement in favor of the claimants operated as a pledge and gave the claimants the right to obtain delivery of the goods. And the respondents, in delivering the goods to GF, deprived them of this same right, enabling the claimants to sue in conversion. If it's okay with the tribunal, I'd like to yield the rest of my time to rebuttals and stand down so that my co-counsel can take up the second issue.
Thank you. Thank you so much.
Good evening, members of the tribunal. Before I begin with my submissions, I just want to confirm that I'm visible and audible to everybody.
Yes.
Yes.
Thank you very much. I am Speaker 2, appearing on behalf of the Claimant Bank MPLC before this Honorable Tribunal today. My submissions before this tribunal will be threefold. First of all, I will establish before this tribunal that clause A1 cannot be relied on by the respondent carrier to exclude its liability, since it's in a fundamental breach of the contract by breaching agreed clauses in the addendum to the MMT bill. Secondly, I would state before this Honorable Tribunal that the Hague rules in the present case apply contractually to the MMT bill of lading, and Article 3, Rule 8 of the Hague rules will apply to strike out clause A1, which seeks to exclude the liability of the carrier. Finally, before this Honorable Tribunal, I would submit that the claimants are entitled to the market value of the goods as compensation and not merely an amount of $500,000, as is sought to be submitted by the respondents. Coming to my first contention, I want to establish and take the tribunal through the two main clauses which the respondents seek to rely on in the present case. On page number 10 of the case study, which has the MMT bill of lading and the terms therein, Clause A1 states that the respondent carrier would not be liable for any damage to the goods caused due to its negligence during periods of loading, unloading, and transshipment. If the tribunal can come with me to page number 12 of the case study, which has the addendum to this document bill of lading, the first clause in the addendum states, and I quote from the addendum, "It is hereby agreed that the cargo will be maintained at all times at a temperature of minus 18 degrees Celsius plus or minus 1 degree Celsius." In the present case, the respondents, in breach of this particular clause, stored the goods in a warehouse at Santos where they were not adequately refrigerated, in complete disapproval of the clause in the addendum, and thereby caused the damage to the containers 6 to 10. We submit that this particular clause, 1 of the addendum, which states that the temperature must be maintained at all times, was of the essence of the contract and went to the root of it. We submit that this was of the essence, since any non-compliance with this clause would render the beef, as it has in the present case, unfit for human consumption, defeating the commercial purpose of the contract. The doctrine of fundamental breach was developed by the Court of Appeal in England, signifying that where one party had committed a breach which was fundamental to the contract, he was not permitted to rely on other provisions in the same contract to exclude its liability. I would like the tribunal's attention to one particular case which is very similar to the facts of our case, this being Captain versus Far Eastern Steamship Company. It's on page number 11 of our written submissions for the perusal of the tribunal. In this case, certain goods were discharged at Singapore and put into transit storage. The defendant carrier in that case knew that goods were not waterproof and were supposed to be carried in covered storage throughout the entire period. The clause in the contract in that case sought to exclude the liability of the carrier based on the fact that the carrier would only be responsible for those parts of the shipment performed by him when the goods were on the vessels under his management, very similar to how clause A1 is worded in the present case. However, the court in that case held that by breaching the contract and by storing the goods not below a deck, which went to the root of the contract, they were in fundamental breach of the contract and put the goods at a greater risk than what was agreed to between the parties.
Can I ask you a question at this stage? In Captain and Fesco, which you very rightly brought to our attention, was not the breach deliberate? The carrier deliberately stored the goods below deck. Now, in this case, there is no evidence that the carrier deliberately allowed the goods to be stowed at a temperature that was too high. Might that make a difference?
Pertinent question, Mr. Abhishta. If I can bring the attention of the tribunal to page number 15 of the case study to answer this question, which has the inspection certificate. As per this inspection certificate, it states that the CRGN employees who were agents of the carrier were aware of the difficulties and the inadequate refrigeration facilities at the warehouse in Santos. Furthermore, this has been reiterated by the claimants in the points of claim in paragraph number 8 of the case study, which is on page number 3. This particular paragraph we submit has been admitted by the respondents in their points of defense. If I can bring the attention of the tribunal to where they've admitted this particular paragraph. Page number 6 of the case study, where the points of defense are mentioned. If we have a look at paragraph 3 of the points of defense, it states that paragraphs 5 to 8 of the points of claim are not disputed. Paragraph 8 of the points of claim of the claimant submits and states very clearly that the CRGN employees and the agent of the carrier was well aware of the fact that the warehouse at Santos was inadequately refrigerated to store the goods in a safe manner. Does that answer Mr. Arbitrator's question?
Yes, I think it does. Thank you so much.
I have a follow-up question. Why are we talking about the doctrine of fundamental breach? I thought that was laid to rest in photo productions and Securicor. I was just old enough to be able to have the tail end of it when I was doing my contract study, and I was very glad to see it go. But perhaps you could, explain why you're referring to fundamental breach.
Absolutely. Mr. Arbiter, for referring why the reference was made to fundamental breach in this case was to submit that as per the doctrine of fundamental breach, which of course you rightly mentioned that there are cases to the contrary as well. However, in fundamental cases of breach, where there are exclusion clauses or limitation clauses, it is the burden of the respondents to show that they're not, in fact, as Mr. Andrew rightly mentioned, in fundamental and intentional breach of the contract and subjected the goods to a higher risk than what was agreed. This is unreasonable deviation from a clause which went to the root of the contract. We submit that when this clause which went to the root of the contract is breached, the commercial purpose of the contract stands defeated, as the goods in the condition that they were delivered to us could not have been intended by the parties to be resold at market value, and they were in fact sold at bet value at a far greater loss than what the parties had agreed to originally. In such a case, when the clause is of the essence of the contract and is breached by the contract, by the carrier, it is a humble submission that they cannot rely on saving clauses in the same contract. However, if this does not satisfactorily answer the question of the tribunal, we have an alternate argument to make with regards to this, and that is without prejudice to the initial argument. May I proceed?
Could you just clarify which is the clause which you're saying they can't rely on because it's a fundamental breach? Just if you could just help you with that.
So if the learned tribunal could come with me to page number 10 of the case study, which is clause A1, at the bottom of the very page, it states that notwithstanding anything else in this bill of lading, the carrier will not be liable in any circumstances for negligence for any damage to the goods carried while the said goods were being loaded, unloaded, or transshipped. This exclusion clause, in our humble submission, cannot be relied on by the carrier when they're in breach of clause 1 of the addendum, which equally obliged them to maintain the temperature of minus 18 degrees Celsius at all times. However, if this argument does not satisfy the tribunal, alternatively we submit that when there's a conflict between these two clauses, that is clause A1 in the MMT bill of lading and clause 1 of the addendum, the two must be harmoniously construed. The way to do this would be by applying the principle of exceptions, or generally as specialibus non-derogant, which states that when there is a specific clause in a contract, it must be read as an exception to the general one without doing violence to the application of either clauses. We submit that clause A1 seeks to limit the liability of the carrier very broadly and generally by stating that the respondents won't be liable for any negligence or default. However, when we come to page number 12 of the case study, it states in the first clause that the temperature must be maintained at all times during the transit, making no exception to the periods of loading, unloading, and transshipment. This particular clause received the express consideration of the parties and was agreed to by the carrier, knowing fully well that he would have to make sure that the responsibility of maintaining temperature lies throughout the entire period of the transit and does not get excluded by transshipment loading and unloading. So we submit basically that in this case, if the respondents had caused the damage to the goods by any other means, let's say, for example, dropping them into the sea or maybe because of an accident, they would not be liable for the same if it happened during loading, unloading, and transshipment as per clause A1. However, the temperature which was to be maintained at all times and must be read as an exception to clause A1 in case there's a conflict between the two. Therefore, in a harmonious construction, it is our submission that the only way to harmoniously construe the two clauses without rendering one of them infructuous would be to hold the respondent carrier liable for maintaining the temperature at all times, including the periods of transshipment. Moving on to our next submission, if there are no more further queries from the tribunal in this regard, I would like to talk about the Hague rules.
I would just like, sorry, Raja, go ahead. Go ahead.
I just wanted to, you referred to the survey report, and you suggested that that was the reason for, that there was a statement there that the storage at the transshipment place was inadequate. Can you refer me to that place?
Yes,
where
Mr.
you find
Arbitrator.
that?
Mr. Arbitrator, if you could come with me to page number 15 of the case study.
Yes.
Paragraph 4, if I may
Yeah.
read from paragraph 4. Our inquiries, with one exception, produced no relevant information. However, we were informed independently by 3 employees of CRGN, who were agents of the carrier, that they had been told by employees of the warehouse in Santos that the electrical connections intended for containers of frozen meat had been malfunctioning in the previous week, that the warehouse owners had failed to remedy this problem, and that there had been complaints from others that it had been difficult to maintain temperatures below -6 to 8 degrees Celsius.
Now tell me, when was the cargo in Santos?
Right. Mr. Arbitrator, the cargo in Santos, if I can point you to the exact date, would be on 17 January 2019, as per page number 2 of the case study, paragraph 3. And it was then transshipped onto the LS reefer on 19 January 2019. So it sat in that warehouse for a period of 2 days.
Now, yeah, but the reference over here, first of all, he says that he actually produced no relevant information. And then he talks about hearsay, talks about an event which took place a week before the survey. That's not 19th, is it?
Right, Mr. Arbitrator. If we look at point B of paragraph 4, it says that the warehouse owners had failed to remedy the problem which was recognized during the previous week.
But that was a week before, not
Right,
3 weeks back.
However, they failed to remedy the problem even after that week, is what the inspection certificate certifies. Furthermore, Mr. Arbitrator, if I may humbly submit, the respondents have already admitted the fact that the warehouse was responsible for the damage to the container 6 to 10, and that the beef was in fact spoiled during transshipment. If I can again reiterate the principle, reiterate the fact where the respondents have admitted this position. Paragraph 8 on page number 3 of the case study of the points of claim states that the goods were not stored at -18 degrees Celsius and were rather stored at -7 degrees Celsius. This is the third last line on paragraph 8. This particular paragraph has been admitted by the respondents in their points of defense, paragraph number 3, which is on page number 6 of the case study. Furthermore, if I can also confirm this fact through another para in the case study, on page number 7 of the case study, under containers 6 to 10, paragraph 14 says that the spoilage in containers occurred during transshipment at Santos. These are the submissions made by the respondents in the present case. Therefore, there is no dispute as to regards to where the goods were damaged or transshipped. The only dispute that lies in the present case is whether or not the carrier is liable for it, and we submit that they are. Does that answer Mr. Arbitrator's question satisfactorily?
Thank you very much.
I will now proceed to my argument based on the Hague rules or the incorporation.
Sorry, but my point was slightly different. I just wanted to reconfirm that currently with this argument that you're making, the claimants are actually saying that the clause A1 is actually valid. However, because it contradicts with the temperature control clause, it is actually invalid in this very case. But otherwise, you're not challenging the validity of the A1 as such. Is that correct?
We are. Mr. Arbitrator, I was just starting with that contention, which is an alternative to the first one. This contention is based on the incorporation of Hague rules. And now Hague rules don't allow for a clause such as clause A1 to be incorporated into a bill of lading like they have in the present case. Now, in the present case, Hague rules have been incorporated voluntarily between the parties, which means that they have to be read in consonance with the other provisions. And we do not dispute that fact. Therefore, Article 3, Rule 8, which states that this liability cannot be excluded by the carrier, will not automatically strike out clause A1, but we submit that it does based on the fact that the respondent carrier undertook certain obligations under clause 1 of the addendum. We submit that Article 3, Rule 2 of the Hague Rules mandates the respondents to properly and carefully load, handle, carry, keep for, and discharge the goods carried by it. The claimants submit that it is for the parties to any particular contract of carriage to agree on what functions the carrier is to perform, But insofar as the carrier agrees to perform those functions, he's obliged to perform them properly and carefully. Now, this specific function in the present case is reflected in clause 1 of the addendum, which states that the temperature of minus 18 degrees Celsius was to be maintained at all times. We submit that in the presence of such a clause, when the respondent carrier undertook the obligation and the additional burden of maintaining this temperature, it has to do it in a proper and careful manner. Any other way that they do it in would be in breach of Article 3, Rule 2. Where such an exercise, where they seek to exclude the liability for a breach of Article 3, Rule 2, that particular clause would get struck out by Article 3, Rule 8 of the Hague Rules, which states that such clauses are not allowed to be incorporated into a bill of lading. Therefore, there is no difficulty in holding that where a liberty to transship the goods has been given to the carrier, along with a clause in the contract that says that his responsibilities will cease once the goods have left his possession, will be struck out as void. Therefore, it is the contention of the respondents that by undertaking the operations of transshipment, they cannot simultaneously seek to exclude the liability for the same.
May I ask one thing about the Hague-Visby rules? Are the Hague-Visby rules incorporated mandatorily, compulsorily, in this contract of carriage? Is that your submission?
Mr. Arbitrator, no. Our submission is not that the Hague-Visby rules are applicable. It is that the Hague rules are applicable contractually and not by force of law. Because there is no current legislation in England which gives it the force of law, since the 1924 Act was, of course, repealed by the 1971 Act, which gives force only to the Hague-Visby rules. But as per the clarifications issued to the case study, we have been told not to include Hague-Visby rules in our contentions, and then they have to be based on the Hague rules of 1924.
Yeah.
We submit that they are.
Can I stop you there? If the Hague rules are not compulsorily incorporated in this contract, what is there to prevent a carrier including a clause like A1, which simply says we shall not be liable? Surely this is a case where there is freedom of contract, isn't it? Or am I missing something? Am I being extremely foolish?
No, Mr. Arbitrator, that is a very pertinent question. I would like to answer that in a simple manner. We submit that if clause 1 of the addendum, which states that the temperature was to be maintained at minus 18 degrees Celsius, did not in fact exist in the current contract, you're very right in saying that the carriers could have excluded the liability under clause A1. However, when a function like that has been specifically undertaken by them, as per the intention of the parties, this had to be performed carefully and properly by virtue of Article 3, Rule 2 of the Hague Rules. Article 3, Rule 8 states that such a clause which tries to exclude the liability of the carrier for breach of Article 3, Rule 2 will be struck out as null and void. We submit that the combined force of Article 3, Rule 2 of the Hague Rules, along with the intention of the parties reflected in the addendum to the Bill of Lading, will not have in the end will result in the respondents not being able to rely on clause A1, since the Hague Rules will in fact cut it out in the present case. Furthermore, if I can submit that Article 3, Rule 2 and the duties under that particular clause are non-delegable in nature, in the sense that the respondents will be liable for the acts and omissions of their independent contractors engaged to fulfill their obligations under the contract. If I can also bring the attention of the tribunal to clause 10C of the Bill of Lading, which is on page number 10 of the case study. Unfortunately, a case that I had cited earlier at Standard Chartered Bank, it was held that the court rejected an argument made by the other side that the bank had suffered no loss as a result of wrongful delivery, since such an argument would deprive the bank of the security provided by the bills. We submit, as per the principles of English law of damages, we have to put the bank in the same position it would have been in had the contract not been breached. Admittedly, if the contract was not breached, the bank MPLC would have been able to sell the goods like it has done in the present case in containers 6 to 10. Even though it has only received the value as pet food value, since the goods were damaged. We submit that if the goods were in good condition and rightly delivered to the banks in containers 1 to 10, the same could have been sold by the bank as security.
No, but I think the question that Simon and I have the same question is, can the bank make a profit?
Right.
That's the question.
Yes.
Should the bank not get 500,000 minus 74,000 because they've sold part of the cargo and not claim for their damage, the excess profit, which they could have made? Is that what's the position of the bank?
Mr. Arbitrator, in this case that we cited, along with the case of Cum versus Water Bank Limited, the bank was held to be entitled to sell the goods at the market value. Now, as for the fact or the law on the point whether or not the banks can keep the excess, the council is not aware of the specifics. But
the question again is, the bank was allowed to sell it at the market. The bank will sell it at the best possible price. What is it that you can claim from the owners is the question as a bank. We're not asking you what you could have sold it for, whether you sold it for a higher amount, etc. But having so, if you come to the court saying the market value was higher than what you financed it for, therefore you should be entitled to the profit as well. Are you allowed to do that in this?
Mr. Arbitrator, it is a humble submission that we are, in the light of authorities cited. However, even if we are not, today the claimant bank is entitled to recoup the market value of the goods. Whether or not it gets to keep the excess depending upon the laws of England with regards to insolvency, since GF has gone insolvent, and whether or not this amount would form a part of the liquidation estate of the insolvent, the council is unaware of the details, and I would not want to make a wrong submission before this arbitral tribunal. However, we are here before the tribunal today claiming the market value of the goods, and whatever the excess amount is will be dealt with as per the English law. Furthermore, Mr. Learned Tribunal, I would like to submit that GVAG, suing in the name of the bank in the present case, is doing so by the doctrine of subrogation. The doctrine of subrogation operates automatically once the insured has paid the assured the amount under the insurance policy and gets placed in the same position and in the shoes of the claimant bank in the present case. We submit, therefore, that where MPFC is entitled to the market value of the goods, GVAG being the insurer, by subrogation can claim the exact same amount before this honorable tribunal.
Is it subrogation only up to the amount that you have paid, with the balance being held maybe in trust for someone? But can you go beyond that? It's not an assignment, it's an subrogation, you said.
I understand that concern, Mr. Arbitrator. In that case, I would like to mention that paragraph number 2 of the case study says that GVAG's assignees of the insurance policy had indemnified the claimants till the extent of $500,000. Now, in the case of Compania Colombiana versus Pacific Steam Navigation Company, it was held that where there's an assignment of the right to sue, even where the insurer is in subrogation, they can recover, in theory, more than 100% of the amount they have paid to the assured. We submit that in the present case as well, the insurer, in theory, can recover more than the market value of the goods, as is sought to be submitted before this tribunal today. And even if GVAG is not, it is a submission that the same would go to MPLC Bank. And in any case, this may be held in trust if the same belongs in the liquidation estate of the insolvent. If that answers Mr. Arbitrator's question, since I have only 30 seconds left, I would like to ask an extension of another 30 seconds so I can sum up the issue with regards to claim of the interest or the compound interest to be claimed by the claimants. It is a claimant's submission that the courts and arbitrators can and usually do order interest to be paid on damages that have been awarded in bill of lading cases. And as such, the claimants claim compound interest from 5th February 2019. That is when the goods were supposed to be delivered to the bank MPLC and in good condition. Section 20, subsection 1 of the International Arbitration Act of Singapore provides for the arbitral tribunal's power to award simple or compound interest on the whole or any part of any sum as it considers appropriate. A similar discretion is also provided under Section 49, subsection 3 of the Arbitration Act of England to remove any doubts. It has been accepted unanimously that a default of payment must effect restitution, not only of the principal sum, but also of an amount that reflects its true use value over the period between the date it was payable and the date it was restituted. We submit that therefore the claimants have been kept out of the money which they rightfully had to receive from 5th February 2019, and therefore, since we were not reinstated for that loss, the compound interest must be calculated from the date of 5th February 2019. Finally, in Sempra Metals versus IRC, the House of Lords concluded unanimously that there was a jurisdiction at common law to award compound interest as damages for a tortious or contractual breach, including both a breach of statutory duty and the late payment. A majority of House also held that Sempra could recover compound interest by means of restitutionary award sought. Following the same approach, since the respondent carries liable for the tort of conversion for containers 1 to 5 and for a breach of contract for containers 1 to 10, we submit humbly before this honorable tribunal that compound interest be awarded to the claimants, starting from the date of 5th February 2019 up till the date the award is made. With that, I would like to stand down and conclude my submissions if there are no more queries from the tribunal.
I have one question, none for you, thank you very much. Just to close, I have one question for speaker number 1, which I missed out. In your claim for conversion in tort, how do you make out that claim in conversion? how do you have the right in tort to claim? When did the damage take place? The cargo was discharged on 17th, right, in Santos, and shipped again on 19th. And the damage would have taken place on 17th and 18th. And I understand that when did you get the right in tort to be able to make that claim?
My speaker is just trying to connect to her internet. I think she's having some trouble. Yeah.
Mr. Arbitrator, it is submitted by the claimants that because the claimants were holders of the bill of lading, they will have a right to conversion because of the fact that the delivery of the goods made to them was subpar quality.
Yeah, but for tort, when did you have title to the goods?
Mr. Arbitrator, as per the law of torts in common law, the claimants would have had title to sue after they received delivery of the goods and received delivery of the bill of lading and honored their payment, but honored the letter of credit by way of payment.
Payment.
But
When was that?
19th January, Mr. Arbitrator.
But if the damage was on 17th and 18th, do they owe you a duty?
Mr. Arbitrator, it is submitted that irrespective of when the damage had taken place, as holders of the bill of lading, the claimant would still have had.
That's in contract. In tort, you made a case in tort. How do you bring in the duty of the carrier to you when on the date that the damage took place, you didn't have any title over the owner, you're not paid for the goods?
Mr. Arbitrator,
you may owe duty to someone else for the damage, but how does it come to you?
Mr. Arbitrator, the case in tort that the claimants had made was specifically for containers 1 to 5. With regard to containers 6 to 10, an implied contract exists between the claimants as well as the...
I'm not on contract. You made your submission on contract. I'm only on tort. You said that you also are making a claim in tort for conversion. How are the owners responsible to you in conversion in tort, when admittedly you paid on 19th and the damage took place probably on 17th, 18th?
Yes, Mr. Arbitrator, but the claims of the claimants in respect of tort were only in connection with containers 1 to 5 and not containers 6 to 10. The claims in relation to containers 6 to 10...
It's irrelevant, 1 to 5 or 6 to 10. You got all the bills on the same day. You paid for all of them on the 19th.
Mr. Arbitrator, it is contended that the only claim that the claimants make on with respect to containers 6 to 10 was based on the contract and not based on tort. It was specifically on the terms of the contract.
No, I'm talking about, let's say, 1 to 5. 1 to 5. How did you get the right in tort under 1 to 5?
For containers 1 to 5, it is submitted that the claimants got the right, the title over the goods on 19th January upon receipt of the bill of lading as well as honoring of the letter of credit. However, as is made clear by me, with regards to containers 6 to 10, the claims made are not in respect of tort.
Noted.
Thank you, Mr. Arbitrator.
Just before moving any further, am I audible and am I clear on the screen? If I have the permission of the respected arbitrators. Greetings of the day, respected arbitrators. I am Counsel 1, appearing on behalf of respondents ES in this current matter between MPLC and ES. The Council shall be dealing with two issues. The issues pertaining to the appointment of number of arbitrators and issues pertaining to the whether claimants have the right to title to sue or no, and whether the respondents are liable under the tort of conversion or no. Whereas my co-counsel on the other hand shall be dealing with issue 3rd and 4th, which talks about the applicability of the Hague rules, and the fourth issue talks about the compensation. It is about the compensation issues. So moving with my submission, as stated earlier, my first issue would be regarding the dilemma about the number of arbitrators that are to be appointed over here. The council, during this course of submission, shall be dividing this issue into two parts, wherein the first part, the council shall be submitting as to how the SCMA rules will apply, and in accordance with SCMA rules, three arbitrators are to be appointed. Whereas in my second part of my submission, the council shall be dealing as to how the effectiveness and the application of SCMA rules will prevail over the International Arbitration Act of Singapore. To begin with, it is very pertinent, respected arbitrators, to note that the document attached on page number 12, document number 2, paragraph number 2, if the Honorable Tribunal would read that paragraph, it is clearly mentioned that in cases of dispute, the arbitration is to be referred to the SCMA, to the Singapore Chambers of Maritime Arbitration. Therefore, it is very clear, and relying on the preamble of the SCMA rules, which clearly states that if at all the parties have agreed that the arbitration rules are to be governed by the SCMA rules, therefore SCMA rules will be the governing law of arbitration in this matter. Therefore, which brings me to my next submission, which is clear that referring to 6.1, rule number 6.1 of the SCMA rules, which clearly states that if at all the number of arbitrators are not decided in an arbitration agreement, as we have in our extant case, where the number of arbitrators are not decided. Therefore, Rule 6.1 clearly mentions that 3 arbitrators are to be appointed. Therefore, coming to my second sublim of the submission, which deals with the fact that, which talks about the effectiveness of the application of the SCMA rules. Therefore, it is very clear. Therefore, it is very important to rely on the on Section 15A of the International Arbitration Act of Singapore, Section 15A, subclause 1, which clearly mentions that, which talks about the applicability of IAA in the cases of institution arbitration. It is clearly mentioned in this very section that the IAA or the model law will only come into picture when the SCMA rules or the procedural rules of the institutional arbitration is inconsistent or derogatory in nature with the IA or the model law. Therefore, which brings me to my next reference, that is Section 15A5, to read it out for the arbitrators. It clearly states that a provision of rules of arbitration is not inconsistent with the model law or the IA merely because it provides for a matter which is covered by a provision of the model law or this part, which allows the parties to make their own arrangement. To sum this entire subsection, it is this basically says that, taking the example of our current matter, wherein Section 9 of the IA, on the other hand, and Section 6, Rule 6.1 of the SCMA provides a solution for a same problem, that is when number of arbitrators are not decided in the arbitration agreement. Therefore, simply because the SCMA rules has an alternative solution to this very problem, it doesn't mean that it is inconsistent or derogatory with that. Therefore, to conclude or to sum it up, it is very clear that referring to document number 2, page number 12, it is clear that SCMA rules will prevail, and therefore by the application of rule number 6.1, 3 arbitrators are to be appointed in this present matter, and Professor Simon Bobbitt would be the presiding arbitrator in this present matter. Before moving further, are there any doubts? Yes, Mr. Abhi.
You hear me now?
Yeah.
As Andrew said, we like our silly questions. My question is, why are we looking into the International Arbitration Act of Singapore? Why is the Arbitration Act of Singapore relevant in this case?
Indeed, Mr. Arbitrator. If we take a look at the submission made by the claimants, they are clearly stating that the appointment of arbitrators should be done in accordance with Section 9 of the International Arbitration Act, which states that, which is not a mandatory provision for the record, but it states that in cases where number of arbitrators is not decided, so Section 9 will apply and a sole arbitrator is to be appointed. For that very purpose, Council was relying on the International Arbitration Act.
I think George's arbitrator's question is, why are you relying on the Act itself? When the rules apply, why are you going into the Act at all? That's what his question is. Correct me if I'm wrong.
Yeah, absolutely, 100% correct.
Mr. Arbitrator, it is very clear that since the seat of arbitration lies in Singapore, that's why the statutory provision of that very country, that is the International Arbitration Act of Singapore, will apply. That's why the Council was referring to the International Arbitration Act of Singapore, and that's why both the parties, for that matter, and in this present matter, IA is mentioned by both the parties. If that satisfies the answer of you.
Yes, absolutely. Thank you. Thank you.
Therefore, much obliged, Mr. Arbitrator. Therefore, coming to my second and my final submission, wherein the Council shall be discussing as to how should be dealing with the issue whether the claimants can sue respondents for breach of contract and whether the respondents are liable for the tort of conversion. Here, the Council, during this course of submission, shall be dealing has divided these issues into two sublimits, wherein the first deals with whether as to how the claimants do not have the right to title to sue the respondents because they have indeed ratified the contract, ratified the delivery of containers 1 to 5. Thereafter, the Council should be explaining as to how the respondents are not liable for the tort of conversion, wherein Council, with help of certain case laws, will justify his claim. Therefore, to begin with my first sublim of my second issue, here, referring to the facts that the containers 1 to 5 was indeed delivered without the production of bill of lading on 3rd February. On that very same day, delivery of containers 6 to 10 was made to Stuttgart instead of Hamburg. Was made to Hamburg instead of Stuttgart on the behest of the claimants. Therefore, the Council submits that when the claimants were cognizant of the fact that the delivery of containers 1 to 5 was done to GF, they failed to raise any objection to it. They, in a way, they accepted the delivery without protest. So the Council claims that, and referring to certain case laws, namely the case of China Light Industry and the case of Kota Maju.
I'm sorry. Did you just say that insofar as 5 of the containers, they didn't raise any objection?
Yes, Mr. Arbitrator.
I thought as per the facts, by the time they told you to deliver, not to deliver and take it to Hamburg, you said you'd already delivered 5. How could they then stop you? That's why they've come and sued.
Mr. Arbitrator, that's what the Council is trying to reiterate. The very fact that the containers, when respondents informed the claimants about the delivery of containers 1 to 5, as being diligent, it was their duty to have a protest or even raise a question as to how could you deliver the containers 1 to 5.
Just show me where you say that. Where do you say that you told them that we are delivering 1 to 5 to?
Mr. Arbitrator, it was not advancedly told to them, but it was told post delivery of containers 1 to 5.
That means it's already done post facto. The cargo's already gone. The protest is filing the case. They stopped you from delivering 5 of them, and the balance was out of their hand because you'd already delivered without the bill of lading. What protest would they do?
Mr. Arbitrator,
for misdelivery.
Yeah, yes, Mr. Arbitrator. The fact that the Council wants to shed light on is that they realize the fact that they asked to change the delivery location of container 6 to 10 was only after the fact that they realized that GF, that is the buyer, was already insolvent.
But it's irrelevant. So far as you're concerned, he's got the bill of lading, and he says, Can you deliver these to Hamburg for me? And I'm the endorsee of the bill of lading. Can you deliver these to Hamburg for me? And I will deal with them thereafter.
Indeed, Mr. Arbitrator. Yes, Mr. Arbitrator.
No, carry on.
Yeah. Mr. Arbitrator, since the fact that what the Council is trying to say, since the claimants are indeed the holders of the bill of lading and they have the right to the goods, the Council is no way denying that fact. But you being the owner of the goods, you don't raise any objection even after delivery of containers 1 to 5. It is very problematic in nature, and the fact that you only raise any objection or you have problem is only after the fact that you realize GF was insolvent. So that's what is problematic in nature.
Do you have any authority which you can cite to us for the idea that you cannot complain of conversion if you did not raise an immediate objection? Because it seems, I think, to me, as a somewhat unlikely idea, but I'm sure you may have some authority I don't know about.
Indeed, Mr. Arbitrator, the council has the certain authorities for it. The council would like for the ease efficiency of answering. The council would be answering this your question in two parts. Wherein the first, the council would be relying on two judgments: the judgment of Kota Maju and the judgment of China Light Industry, which is very similar to our case. Here, the delivery was made without the bill of lading, but the holders of the bill of lading failed to make any objection to it. Therefore, the court here held that if the goods are delivered without the bill of lading and the party raises no objection to it, thereby the party loses its right to claim against the carrier and therefore therefore loses its right to immediate possession. Thereby, it brings me to my second part, the question that Mr. Arbitrator was asking regarding conversion. Here, in the case law of Paul Wilson, here the Queen's Division bench held that when a party shows sufficient intention to abandon its right, it forgoes its right to immediate possession and thus its right to claim damages on conversion. The very definition of conversion, Mr. Arbitrators, it's very clear that if at all a party deliberately interferes with the right to immediate possession of a chattel, thereby the party is liable for the tort of conversion. The very element of tort of conversion is defied in this very case when the claimants fail to raise any objection, thereby ratifying the delivery of containers 1 to 5 and therefore relying on the judgment of Paul Wilson, which clearly mentioned, as the council stated before, that a party shows sufficient intention to abandon its right, it forgoes its right to immediate possession and thus its right to claim and conversion. If that satisfies the answer of respected arbitrator.
I think you may have some difficulty in persuading my brother arbitrators, but I certainly understand your answer.
Can I just clarify one thing? Can I just clarify one thing? Your argument or the arguments from the respondent seems to be that the bank were not quick enough to flag off the fact that these 5 containers should not have been delivered to GF. The facts are, and correct me if I'm wrong, the facts are that they actually got the delivery of the containers was made to GF on early 3rd February. Within the same day, the banks flagged off and requested the other containers to be delivered to another destination. And you still contend that there was delay in this. You still contend that. I just want to reconfirm that, yeah? Indeed,
Mr. Arbitrator. Also, I have, if at all the council permits, since the claimants have been relying on Hague rules for the sake of argument, assuming but not accepting if Hague rules do apply, there exists a limitation period provided in Article 3, Rule 6 of the Hague rules. To read it out, it clearly states that if in any event the carrier and the ship shall be discharged from all liability irrespective of the loss or damage unless suit is brought with 1 year of the delivery of the goods. So here, Mr. Arbitrator, the cause of action was in 2019 and this current arbitration is happening in 2021. As I stated earlier, it's just an argument. We don't we rather deny that our Hague rules were applied. But since the claimants were claiming,
you've not taken that ground of limitation anywhere in your defense. So I don't think that really,
Indeed, Mr. Arbitrator.
Not really something that you've taken anywhere.
Yes, Mr. Arbitrator, that was just for sake of argument. As I stated, it was just assuming but not accepting since the claimants were using Hague rules.
The issue here is, if you read paragraph 7 of the points of claim, the cargo arrived, then 5 trucks delivered their containers 1 to 5 to GF early on 3rd February. The same day, these containers were resold and driven away on their other trucks provided by third party. Also on the same day, the claimant, fearing GF's insolvency, asked the respondent ES to deliver the containers, that means all the containers, to a cold store in Hamburg, selected by them and handed over the MMT bills to ES. So they were the endorsee of the bill of lading. They had the original bills of lading. They came and gave you the original bills of lading. And he said, look, I'm the owner of these bills. I'm the owner of these goods. Can you please have these delivered to my cold storage in Hamburg? By which time, you had already delivered 5 to someone else.
Yes, Mr. Arbitrator. To again have to stand firm on what the council's point was. Council was basically trying to say that the delivery of containers 1 to 5, since there were 10 containers, that is, containers were divided into two parts, containers 1 to 5 and containers 6 to 10. Therefore, the value in the eyes of the claimants of this container is very high indeed.
Just following my brother's question, do you have any case law which says that you can give delivery of goods without the original bills of lading being presented?
Mr. Arbitrator, the council has a case law which talks otherwise if the delivery was made without the submission of the bill of lading and the claimant and the party fails to make any protest or protest regarding that issue, then for that I have two case laws for that matter.
Can you read out the paragraphs that you're relying on in the case laws? Because I don't have the case laws with me, unfortunately.
Mr. Arbitrator, if I apologize that I haven't submitted a compendium, so it would be very difficult for you to follow with that case law. So the case law is it's indeed a Chinese judgment. It's
is that binding to the English courts or the English arbitral tribunal?
Mr. Arbitrator, since this is an arbitration proceeding, any judgment or any precedent would not be binding. It would just have a persuasive effect. Everything else lies in the with the arbitral tribunal.
I would imagine English law would be binding on us. Yeah,
indeed,
it's under English law, but
Mr. Arbitrator,
yeah, both your judgments are Chinese?
Indeed, yes, Mr. Arbitrator.
I think you may find it being argued that the Chinese legal system does not recognize the tort of conversion, and therefore any decision of a Chinese court is unlikely to be regarded as relevant. We're open to persuasion, but you have a very steep hill to climb.
Yes, Mr. Arbitrator, and I'm determined enough to do that for the sake of persuasion of the arbitral tribunal. So therefore, as I stated earlier, so as I mentioned that there are two case laws in regarding with tort of conversion, which clearly states that if the parties have forgone their right, therefore they do not have when they have forgone their right, they are deprived of the right to immediate.
Perhaps you could take one of the case laws and just read out something which has been written there so that we can understand in what context the court said so.
Indeed, Mr. Arbitrator. So mentioning the judgment of Pierce versus Bemis here, the Queen's Division Bench, and even in the judgment of...
But that's an English law judgment, if it's Queen's Division Bench.
Yes, Mr. Arbitrator.
But you just said there were two Chinese judgments.
Yeah, the Chinese judgment is for the misdelivery of the goods, whereas these case laws are for the tort of conversion. These two English case laws.
And in the English case laws, it says in a tort of conversion, if notice is not given, then we lose the claimant loses the right.
Mr. Arbitrator, it states that when a party shows sufficient intention to abandon its right, it forgoes its right to immediate possession and thus right to claim and damages in tort of conversion.
But wouldn't starting an action against you mean something?
Mr. Arbitrator, so this very argument flows from my previous submission wherein the council stated as to how the ratification or the acceptance of containers 1 to 5, acceptance without the protest led to them foregoing.
Where is the ratification? You've given it away.
Mr. Arbitrator, the ratification or the waive off that happened was when we, as I stated earlier, since the containers 1 to 5 was delivered on 3rd February, containers 1 to 5 were delivered earlier than containers 6 to 10. So between that window, we had informed the claimants that we have delivered containers 1 to 5 to GF. So between that time, what the council is trying to claim is that the claimants failed to raise any protest during that time. So that is really problematic. They should have told us how could you deliver it, or they should have protested against that.
But why should they tell you? Are you not? If you read your bill of lading, let's forget anything else. If you read your bill of lading, and if you just come to your bill of page, my apologies, page 10, and it talks about delivery of goods to consignee. Did you do any of the three?
Mr. Arbitrator, before coming to your question, also one more thing that they asked us to change the delivery location. They were like, change the delivery location. We wanted to deliver to Hamburg instead of Stuttgart because they feared the insolvency of Virgin. I believe
Irrelevant.
Mr. Arbitrator has a question.
I mean, change of destination, you may say that I want to charge you differently. You want to now go to Hamburg instead of Stuttgart, that may have a change in price. But how, I mean, the fact that they're going bankrupt, the question is, you're supposed to give delivery of the goods in terms of your MTO bill of lading, in terms of clause 8. 8, did you do any of that?
Mr. Arbitrator, yes, the container 6 to 10 was delivered on the behest of the claimant.
We're not on 6 to 10, we are on 1 to 5.
Mr. Arbitrator, indeed, if you go through the main, that is the page number 9, where the where you have the party's name on the multi-doc, the front page of the multi-doc, it is clearly mentioned in the lower part that number of original empty bill of lading were issued. There were 3 multimodal transport bills that were issued in this case.
So,
since the MPNC is not a consignee per se, but an endorsee, so what the council is trying to point out that since there were three bill of lading issued, there's a high. It is not mentioned somewhere that anywhere that GF was not the holder of the bill of lading. So it can be.
You have to satisfy yourself.
Indeed, Mr. Arbitrator. Mr. Arbitrator, as mentioned, there are 3 bill of lading issued in this matter. FDS gave their bill of lading to MPNC. So one bill of lading is gone. Then ES, as the carrier, has 1 bill of lading. Thereafter, the 3rd bill of lading has to be.
Where is the carrier has the 1 bill of lading?
Mr. Arbitrator, consigner, and the freight forwarder has the bill of lading.
A bill of lading, if it's a title document, you issue it, you give it all 3 to the shipper or consignor. He then deals with it. He's given all 3 under the LC to the bank, and the bank has all the bills.
Apologies, Mr. Arbitrator.
Unless you can show me anywhere that it's otherwise the case.
Mr. Arbitrator, it's not explicitly mentioned in the case. So it is clearly, I mean, it can be fathomed that since 3 bill of ladings are there, and in original circumstances, one is with the consignee, one is with the consigner, and one is with the freight forwarder. Therefore, consignee in this case is not mentioned, and the consignee's bill of lading is with the the consigner's bill of lading is with the claimant, since they have endorsed.
You can carry on. I think you can carry on.
If I have the permission of the respected arbitrators, could I get extra 1 minute so I can just sum my entire show up? Yeah, sure. Much obliged, Mr. Arbitrator. So, as mentioned, as to how 3 arbitrators are to be appointed in this present matter, since SCMA rules will prevail over IAA. Thereafter, in my second issue, the council submitted as to how, since there was a ratification or a waiver of ownership and the rights attached with containers 1 to 5, therefore the claimants have lost their title to immediate possession with the containers 1 to 5. And thereafter, since they have no immediate right to possession, therefore they cannot claim for tort of conversion, and the council humbly submits that the respondents are not liable for tort of conversion. Are there any further questions?
I have one quick question. The claimants raised the point that the multimodal transport bill of lading is a negotiable document under COXA 1992. Do you have anything to comment on that? Is there anything you would like to mention in that respect? I can't see anything in your submissions about that. I'm wondering whether you have anything to argue as to whether the multimodal bill of lading is a negotiable document.
Indeed, Mr. Arbitrator, the multimodal transport MMT bill of lading is indeed a bill of lading, and it is a negotiable document. So that's an affirmative answer from the council.
So you admit the point of the claimants?
Indeed, Mr. Arbitrator, if there are any further questions as to the applicability of the COGSA or the Hague rules, that shall be dealt by my co-counsel, wherein she'll be explaining as to how the applicability of Hague rules will cease to apply in this present matter.
Thank you. No questions for me.
It was indeed an honor to argue in front of the respected arbitrators. Thank you.
Thank you.
Before starting, just to check, am I audible? Thank you. Greetings of the day, respected members of the tribunal. This is counsel number 2, representing respondents ES in the present matter between MPLC and ES. If the members of the tribunals are ready, the counsel may seek permission to move towards her submissions. Much obliged. Counsel today will be dealing with the next 2 issues, which are related to the incorporation of Hague rules and the cost of compensation. Coming to the third issue, the council's main issue here would be to prove as to how the application of Hague rules would not be mandatory and would not be mandatory and it won't be applicable in the present case. And Article 3, Rule 8 of the rules will not render the clause A1 of the bill of lading null and void. As it has been contended by the counsels of the applicants that the Hague rules apply to the present contract. However, the counsel did not had any substantive backing to prove as to how the Hague rules apply mandatory in this contract. Therefore, to prove the council submission as to how these rules do not apply, the council will be dealing with this issue presently. Now, the spoilage in the containers 6 to 10 occurred during transshipment at Santos, and therefore, under clause A1 of the bill of lading, our clients bore no responsibility for the damage. Now, the council attempts to establish this in a twofold manner. The council, in her first sub-issue, will be dealing as to how the incorporation of Hague rules will not be applicable in the present dispute, and in the second. In the second sub-issue, the council will show as to how under the MMT bill of lading, these rules will not be applicable. So, starting with the first sub-issue, Hague rules apply to a contract either mandatorily or voluntarily. So, when the rules apply voluntarily, a clause in conflict with the rules will override the rules. Now, the council submits here that in the present case, the rules do not apply because the mere fact that the English law is applicable to the present contract is not in itself sufficient to apply these rules. It does only so if certain conditions of these rules have been fulfilled. As it has also been held in the case of Comninos, the judge over there held that the rules did not apply because although the application of the law over there was English law, the bill of lading was issued in a non-contracting state, and so the conditions that are needed for the application of these rules were not fulfilled. Now, directing the tribunal's attention to the present case, the impunged bill of lading was issued in Brazil, which is a non-contracting state. Therefore, the rules will not apply. Furthermore, relying on the English case law, relying on the UK law, the UK applies COGSA 92, in which it gives effect to the Hague-Visby rules. Whereas the present case says that Hague rules will be applicable. Therefore, relying even on that.
Can you just show me from the 1992 COGSA where it says the Hague rules are applicable?
The council here is trying to say that the Hague rules are not applicable to the COGSA 92. Hague-Visby rules are applicable.
Where is that?
If you can, if I may direct the attention, the council would like the tribunal to refer to section 5.5 of the rules of the COGSA Act 1992.
Do you mean the COGSA 1971? I think you have the wrong COGSA.
The council, if I may refer, the council, if the council is correct, the clause 5 of the Section 5, Clause 5 of the COGSA 1992 says that the preceding provisions of this Act shall have effect without prejudice to the application in relation to any case of the rules, that is the Hague-Visby rules, which for the time being have the force of law by the virtue of Section 1 of the COGSA 1971.
So when you talk about the Hague-Visby rules being applicable, you're talking about the 71 COGSA.
Mr. Arbitrator, the Council here is trying to establish the fact that even if the English laws are applicable and even if the Hague rules are applicable, the conditions that are required to fulfill the applicability of these rules are not fulfilled here. That is, the bill of lading was issued in a non-contracting state, which is Brazil, and therefore implicitly Hague rules will not apply to the instant case. Moreover, to sum it further, the Council believes that there exists a difference in opinions concerning the application of Hague rules to multimodal contracts. Therefore, these rules do not explicitly mention multimodal transport like the others international conventions like the CMR do. So their scope does not cover the multimodal transport, that is the C segment of the contracts, which includes other types of carriages besides carriage by sea. Another objection to considering that these rules are not applicable under the multimodal transport bill of lading is that such a bill of lading, when such a bill of lading is likely to be a received for shipment bill of lading, the rules do not apply. So to further establish this, whether received for shipment bills of lading are also document of title, this has not been yet decided in the English Court of Law. As a result, its status is not sure. So the Council here would like to point out that although it has been cleared in the case of Mayhew Food Limited versus Overseas Containers Limited that a bill of lading issued for combined transport is subject to COGSA and the rules, the judge there did not clarify whether the bill of lading was the received for shipment bill of lading and the signed for bill of lading. But the very fact that it was issued after the first C stage of transport may indicate that it was a shipped for bill of lading. Therefore, to sum up, the Council since the stance on received for shipment bill of lading is not clear, and in the present case, the bill of lading is a received for shipment bill of lading, it will not cover the rules.
Excuse me, may I stop you for a moment? You, I think, quite rightly say this is likely to be a received for shipment bill of lading. Have you any authority that the Hague rules cannot apply to a received for shipment bill of lading?
Mr. Arbitrator, as it has already been established by the Council as to how under the current case, with the application of English laws, the Hague rules do not apply to the present case since the bill of lading was not issued in a contracting state. Additionally, furthermore, coming to to answer your question, the status that the received for shipment bills of lading under the multimodal document title of the bill of lading has not yet been cleared. The stance on received bills of lading under a multimodal bill of lading is quite unclear. So relying and giving another argument as to how these rules are not applicable, the Council believes that this point shall also be considered in the present case.
Can I ask a question of you? Surely the Hague rules apply to this contract because that's what the contract says.
Relying, yes, Mr. Arbitrator, but there are, as mentioned earlier, there are certain, the mere fact that English law will apply to a contract does not prove that the incorporation of Hague rules shall also be mandatory. Whereas
isn't the Hague rules incorporated into the contractual terms itself?
Yes, Mr. Arbitrator.
The point that Simon is making here is that isn't the Hague rules already part of the contractual term? if I make it part of the contractual terms, don't you have to read the contract subject to the Hague Rules? Unless there is any inconsistencies with English law, which may be otherwise looked at.
The council here believes that in the contract, it is nowhere expressly mentioned that the Hague Rules will be applicable, whereas there is no clause paramount to prove that these rules will apply to the present case. The only condition which is provided is that the contract shall be governed by the English law. Therefore,
with respect, Council, that's not correct. The Hague Rules are clearly incorporated, aren't they? Is it the addendum? If there's a clear incorporation, it's nothing to do with English law or anything. It's what the contract says. And your argument, which you started with, was that the Hague Rules, because they've been voluntarily incorporated, you're not bringing in Article 3.8. Am I right in summarising how you're arguing?
Yes, Mr. Arbitrator.
Thank you.
Yes. So here the council is trying to establish that Hague Rules will not be applicable because it goes against the applicability rule which is to be decided under the English law, which is that under Hague Rules there are certain conditions which needs to be fulfilled under Article 10. And Article 10 says that the Hague Rules these rules will apply if the bill of lading is issued in any of the contracting state. But in the present case, the bill of lading was issued in Brazil, which is not a contracting state. Therefore,
but Council, isn't that when it is statutorily applicable? Not if I wish to include it by contract.
I apologize, Mr. Arbitrator. Your voice was breaking. The council would really appreciate if you could repeat the question.
I said, isn't it the case, Council, that what you're arguing would be the position if it had statutory application, or depending on which country is bringing it into force in their law, but if I contractually incorporate the rules, then those rules become contractually applicable irrespective of the country having effect on it or not.
Yes, Mr. Arbitrator, but as in the present case, English laws are applied and therefore...
Do you have any authority which says, under English law, which says that the Hague Rule cannot be made applicable because Brazil is not a party to the Hague Rule, even where the contract specifically incorporates the Hague Rule?
Yes, Mr. Arbitrator. So in the case of, as already cited, in the case of Comninos S, that is Hellenic Steel versus Salmas Shipping Company Limited, it has been held that the rules will not apply. There, in that case, there was a dispute regarding the Greek law and English law, and the judges held that although the applicable law was their English law, the bill of lading, which was issued in a non-contracting state, and therefore, referring to that, the conditions for the applicability of these rules were not fulfilled, and there the judges held by this reasoning that the rules will not apply to the present case. And therefore, relying on that case law, the council here believes that in the present case also, as the bill of lading was not issued and under English law in a contracting state, these rules shall not apply, mandatorily apply to the present contract.
Council, may I perhaps try and get you back on track, because nobody's arguing that the Hague-Visby rules apply. It seems to be accepted by both sides that the Hague rules apply and contractually, and the issue is what's the effect of Article 3.8 in that situation? I mean, so I think you've already won any battles about the non-applicability of the Hague-Visby rules and the Comninos S, but I just wonder if you could redirect you to the battleground you are fighting on.
Because in fact, in your own defense, you have in paragraph 15 discussed the Hague rules as being applicable. So, I mean, I don't think there's an argument that the Hague rules don't apply.
There's no argument that the Hague rules are not mentioned in the present contract, but the council is here trying to prove as to how in the present contracts their applicability will not be mandatory because of the fact that they haven't been issued in a contracting state, and the plus that multimodal the stance on the multimodal document coverage of the rules under this multimodal bill of lading is not yet being cleared since it is a received for shipment bill of lading. So relying on these two contentions, the council believes that these rules will not apply to the present case.
Okay, I'll just try one last time just to clarify this. It is agreed, at least in the factual background given to us, the case is having clarity in terms of the fact that contractually, Hague rules are agreed between the parties. Just correct me if I'm wrong. Based on that, you're saying that the bill of lading may not actually have Hague rules applying because it's not a contracting party, that is the load port or where the bill of lading is issued. So the contract is independent, has Hague rule applicability, while the bill of lading doesn't have Hague rules applicability. Is that what you're saying? I just want to reconfirm this, yeah?
Yes, Mr. Arbitrator. Apart from that, the council would here like to submit that even assuming but not accepting that the rules apply, and how the council from the applicant team has used the principle of contra profundum term here. So relying on that principle, the council from the applicant team has held that the duty comes against the respondent when they are drafting a written document which contains an exclusion clause. Therefore, the council believes that principle is not being that principle will not be relevant in the present case by proving 3 points. The principle applies when there is some ambiguity in the clause. The council here believes that there is no ambiguity in the present clause. Therefore, both the parties have intentionally agreed to the inclusion of that clause in the bill of lading. Therefore, afterwards, when a dispute arises, the other party cannot come and say that now we do not want the inclusion of this clause. There has been equal bargaining. Both the parties have been in an equal bargaining position before entering into a contract, and that is when they have entered into a contract. Whereas the parties have validly negotiated all the terms of the contract. Therefore, the council later on, when a dispute arises, cannot say that due to this principle, the liability lies on the respondent and they'll be liable for the breach, and we stand by the view that this clause now stands void. Therefore, relying on this other contention, the council believes that even if the rules apply, then also because the rules were negotiated equally by the equal bargaining power, the council here believes that the clause A1 will be valid. Apart from that, the council has raised another contention that the clause 1 of the addendum, which is given in the addendum, that is an exclusion for the clause A1. So the council here believes that the clause A1, which is given in the MMT bill of lading, talks about liability, whereas the addendum being a part of the contract, the clause 1 of the addendum talks about the duties in good faith which the carrier has to perform. They have mentioned a duty that this has to be followed. Now, it is subject to clause A1, but it is not contradicting to clause A1 because the council believes that even if the addendum supersedes the bill of lading, the clauses will be in contradiction to the other clauses only. The clause will supersede the clause only when there is a contradiction with the two clauses. Therefore, this contradiction arises if the council would have raised a question related to the choice of law clauses. That is the law and jurisdiction clause and the choice of law clause, which is given in the clause 3 of the addendum. But in the present case, clearly clause 1 talks about the duty and clause A1 talks about the liability. Therefore, you cannot exclude a clause saying that by issuing an addendum, we have provided an exception to the clause. Therefore, relying on these two contentions, Council humbly submits that clause A1 of the bill of lading will be valid and the respondents will not be liable under breach under Article 3(2) and E8 will not render clause A1 of the bill of lading null and void. Now, as the council is running out of time, the council will quickly come up to the last issues if the members of the tribunal had no further question. Much obliged. So, coming to the last issue about the cost of compensation, the council will be dealing the issue in a threefold manner, whereby the council will be establishing as to how no liability falls upon a client to pay damages. Then assuming but not accepting that even if the claimants are entitled to compensation, they can only recover the loss but not the value of the containers, meaning they cannot claim for more what they paid for. And finally, the council will be establishing as to how no compound interest shall be provided in this given case. Now coming to the first sub-issue as to how no liability falls on our client to pay damages. Our clients are not liable to pay damages for the compensation for the goods due to the voluntary ratification on behalf of the claimants, as has been proved by counsel. Furthermore, clause A1, as has been established in my previous arguments, that the clause is not null and void and it is valid. Therefore, relying on the clause, it absolves all the liability of our client, because in the present case, they have caused negligence while refrigeration, while the goods were being transshipped. Now, coming to the second sub-issue, assuming but not accepting, even if the claimants are entitled to compensation, they cannot claim for more than what they paid for. So, relying on the English case law of INS, in that case, the cargo of telephones were delivered by the carriers without the presentation of bill of lading. There, the judges held that the amount amount of damages shall be calculated by the invoice price, even though it was lower than the wholesale price that was given. In the instant case, the commercial invoice strictly mentions that the price that was decided upon, which is USD 500,000, that should be provided. By this principle, the cost of compensation, that is the loss, will be calculated on this value and not the market price.
Can I just ask? Can I put one thing to you? Why should we not say that the bank recovers the market price, but then has to transfer any excess to the bankrupt buyer? Would that not be a much more sensible solution?
Mr. Arbitrator, the council will be answering your question, but as the time has been, as the council is running out of time, the council will request for an extension of 2 minutes so that the council can answer the question and then quickly conclude the arguments. Much obliged. So to answer your question, coming to the next argument of the council, additionally, in the present case, the GWAG, the insurers, have sued our clients in the name of claimants by subrogation. Therefore, GWAG had only insured the claimants for an amount of 500,000, whereas in the present case, they are claiming for amount of 5,96,556 along with interest, which is inappropriate, as GWAG cannot claim for what they have paid. Hence, hence the claimants should only be compensated for what they have suffered the damages and not at the market price. Now, to further move on to the issue of compound interest, the council here believes that no compound interest shall be granted. To prove that, the council will be relying on some case laws, as it has been held by the courts of England in the Sprung versus Royal Insurance Limited, that paying compound interest causes complexity and promotes longer institution of suits. Therefore, relying on that principle, in the further case of London Chatham and Dover Railway Company, it has been established that the courts have come across with some exceptions, in which case compound interest shall be granted. So relying on that principles, there are few exceptions which have been pointed out. So the compound interest can be awarded, number one, when the contract provides for it. to be paid. Number 2, when the course of dealing or usage of trade creates an implied term for payment. Number 3, it can be paid in equity resulting from the misuse of money and as special damages. Accordingly, in the present matter, the MMT Bill of Lading provides for no such clause which expounds on compound interest to be paid as compensation, nor was implied in any manner. Therefore, also there was no misuse of money from the carrier's side. Therefore, the case does not fall within the exceptions of compound interest. Therefore, the council submits that our client bore no responsibility to pay any compound interest on the damages. Now, to quickly sum up all the arguments, the council, it is humbly submitted by the respondent before the Honorable Tribunal that declare that this tribunal has jurisdiction to hear the merits of the respondent's claim, find that respondents are not liable for the breaches of contract, Hague Rules and tort of conversion as has been argued, and finally award no such damages to the claimants as claimed. Thank you.
Thank you.
It was honor pleading before the Honorable Tribunal.
Thank you.
Pleasure is mine.
Thank you.
Thank you very much.
Members of the tribunal, may I begin with our rebuttals?
Of course.
Yeah.
Our first rebuttal has to do with the contention of the respondents with regards to the applicability of Hague Rules. The respondents sought to argue that they do not apply mandatorily. However, we never disputed this position in our submissions. We admitted that the Hague Rules are incorporated only contractually and do not have the force of law. However, as per our submissions, Article 3, Rule 8 will still apply to strikeout clause A1, even when the Hague Rules are incorporated voluntarily, given the effect of the intention of the parties reflected in the addendum to the Bill of Lading. Furthermore, the Council for Respondents sought to submit that there is no ambiguity when it comes to the construction of the two clauses which are in conflict in the present case. We submit that this is an erroneous argument, since the two clauses cannot be read together as they stand currently and be given strict application to them. If you look at clause A1, it states that the respondents won't be liable for any damage caused due to the negligence, while clause 1 of the addendum states that the temperature must be maintained at all times. The respondents' counsel sought to submit that this was merely a good faith obligation. They always submit that this intention cannot be clearly expressed to the parties as per the contention of the respondents, and that this was meant to impose a legal obligation on the parties to maintain this temperature at all times, and it is not merely an obligation in good faith, which the respondent carrier can conveniently choose to ignore just because of the inclusion of clause A1. Therefore, there is an ambiguity with the construction of the two clauses. In our submission, clause 1 will prevail over clause A1 as an exception, and the temperature had to be maintained at all times, including the period of transshipment. Finally, to sum up the rebuttals for containers number 1 to 5, it was sought to be argued that the bank did not raise any complaints with regards to delivery of containers 1 to 5 when they were delivered. However, in the statin, it has been established that by the claimants that the carrier that delivers without the production of bills of lading does so at his own peril. So while he may be free to do it, if things go wrong, subsequently the carrier will be liable because the bill of lading clearly establishes that a surrender of the bill of lading must be made for the rightful delivery of goods. Furthermore, the carrier is obliged to deliver upon the production of bills of lading as per the case of the FUDA. With that, I would like to conclude our rebuttals, and it was an honor arguing before this esteemed panel of arbitrators.
Thank you so much.
Am I audible and am I visible?
Yes, you are.
Okay. May I have the permission to begin? Okay. So, respected arbitrators, the council shall be making its constructive analysis on the arguments made by the claimants, wherein the first argument is regarding the application of the International Arbitration Act. The claimants failed to provide as to how the SCMA rules is inconsistent or derogatory with the provisions of the IAA, and failed to provide as to why Section 9 IA will prevail over Rule 6.1 of the SCMA rules. Which brings me to my next rebuttal, wherein the council claims that the claimants failed to establish how Hague rules are mandatorily applicable, whereafter even assuming but not accepting a simple arguendo that Hague Rules, Article 3, Rule 6 clearly states that a notice of loss of damage must be given in 3 days and also provides a limitation period. That is the limitation period that makes the claimant's argument fall flat on their face. Thereafter, coming towards my next argument, the claimants have been claiming as to why unfair trade terms will apply in this matter, but respondents contend that the unfair trade term would not apply in this matter because Section 26 clearly states that the Act does not apply to international contract, wherein the extant transaction is international in nature. Thereafter, coming to my next rebuttal, wherein the council submits that if we compensate the claimants, it would unjustly enrich them and wrongly enrich them. Therefore, coming to my final submission, wherein the council claims that submits that the claimants is not in a business to use the money to further purpose. They merely have the right to receive the invoice of price, if at all, not any profit, let alone any an interest. So with this, I am done with my rebuttal. Thank you, respected arbitrators. It was indeed an honor for me to argue in front of this esteemed panel.
Thank you.
Thank you very much.
Thank you.
Thank you, judges and the participants. So this brings us to the conclusion of the final round of 8th NLUO IMAM. I request the participants and judges to join their respective rooms. The participants can wait in their prep room, and the judges are requested to join the judges room, which is available in the top right corner of their panel.